So Lynn Markham and Becky Roberts are your presenters today. Lynn is a land use specialist with CLUE. Her extension work focuses on zoning and boards of adjustment and appeals and land use tools and techniques to assist communities. Lynn provides research-based information, policy options, and community case studies. She has written several publications on shoreline zoning and is co-author of the Zoning Board Handbook. Becky is also a land use specialist with CLUE. She provides training workshops for plan commissions and other local land use officials. She also assists communities with comprehensive planning, public participation, plan implementation, and the fiscal impacts of land use decisions. Becky is the author of the Plan Commission Handbook and co-author of the Zoning Board Handbook and Land Use Megatrends. Lynn will begin the presentation this morning.
Let me see. Okay, so good morning and welcome to our webinar. My name is Lynn Markham and I'll be presenting the first part of today's webinar, and Becky Roberts will be presenting the second part. I want to take just a moment to point out some of the components of the image you're looking at as they apply to conditional use decisions. When deciding on conditional uses, people must follow Wisconsin statutes, state law, which are the thick books shown in the back, as well as their local zoning ordinance shown up front. Then there's a notebook shown for capturing your thoughts about the evidence presented during a hearing and whether it meets the legal standards, plus any conditions you might want to add. So before we dive into conditional uses, I also wanted to share this list of upcoming webinars. The topics are Floodplain 101 by DNR staff on October 7th. The link for registration to that is on the CLUE website. And then CLUE will be offering variances on October 29th and a webinar on refreshing your zoning ordinance on November 30th. I hope you can join us for these upcoming webinars. Okay, so a very brief introduction to zoning. A zoning ordinance contains two parts. The first is the zoning map, which divides the community into districts as shown here. And the second part is the text. The text includes a number of things, including the purpose of the regulations. Why do we have this zoning ordinance in the first place? Which uses, land uses, are allowed for each district, what the dimensional standards are, and any other requirements. When making zoning decisions, there are three different types, and the different types have different levels of discretion or flexibility. The legislative decisions, which are adopting plans, ordinances, and amendments to either one of those, has a high level of discretion. The only requirements are that those decisions have to be reasonable and constitutional. Because these decisions are made by elected officials and they're legislative decisions, public participation is encouraged, anywhere, anytime. Conditional uses falls in this middle category of quasi-judicial decisions, decisions made like a judge would make them. There are predetermined standards that have to be applied. Additional conditions may also be applied, and discussion should happen only during the hearing, not outside of the hearing room and not any other time or place. The third type of decisions are the administrative decisions. These have the least discretion. You're applying the ordinance as it's written, and no additional conditions may be applied. Okay, so let's look a little bit at the history of conditional uses. Back in the 1920s, the Standard State Zoning Enabling Acts authorized the Zoning Board of Adjustment or Appeals to make what they called special exceptions to the terms of the zoning ordinance. In the 1960s, conditional uses were widely accepted as a way to add flexibility and discretion. In 1973, conditional uses, we'll also call them CUPs sometimes for short, were addressed by the Wisconsin Supreme Court and decided that conditional uses were synonymous or the same as special exceptions. So when you see special special exceptions in Wisconsin's law, it also means conditional uses and vice versa. And then in 2017, believe it or not, for the first time, the term conditional uses was actually added to Wisconsin statutes and defined as related to zoning. So if we look at the land uses allowed for each zoning district, there are three categories. There are permitted uses, shown here on the left, green, always allowed. The use is listed and allowed by right in all parts of the zoning district. These permitted uses are granted by the zoning administrator. Conditional uses. These uses must be listed for that zoning district, and they may be allowed if they're suited to that location. Conditional uses can be decided by the zoning board, by the plan commission, sometimes it's called the zoning committee, or the governing body, such as a county board or a common council. And prohibited uses are those uses not listed in the district or those that are expressly prohibited for that district. Those are all prohibited uses. If a property owner desires one of those uses, they can apply for a rezone, or if the local government allows it, they can apply for a use variance. So the Center for Land Use Education did a survey this month of cities, villages, towns, and counties in Wisconsin, and we got 160 responses to that survey. And this is one set of results. So which body has the final authority to make conditional uses? The most common body was the Plan Commission or Zoning Committee, and next was the governing body, and third was the Zoning Board. Okay, so just real brief on conditional uses. They have to be listed for the zoning district. It's a discretionary decision. The CUP may be granted or denied based on the requirements listed in the local ordinance, and conditions may be attached. So now we're going to do our first poll.
So Lynn's going to launch the poll while I read the question for you. We're asking you to respond to how familiar are you with conditional use standards in your zoning ordinance? Please select one. Not familiar, somewhat familiar, I've read them, or very familiar. We've used them regularly when making conditional use decisions.
So I'll give you a few seconds here to finish putting in your answers, and then I'll share the results of this poll. It's like just a few more people entering. Okay. So here are the results that we have. 64% said they're very familiar with their conditional use standards. We use them regularly when making conditional use decisions. Great. Some people, we had 26% that said somewhat familiar. I've read them. That's good. And a small percentage, 11%, that are not familiar. If you are a decision maker that makes conditional uses, I recommend you look at them in your zoning ordinance. Okay, so I'm going to close out of the poll and we'll continue. So the next part of this presentation is going to be some recent case law, some recent court decisions that set precedent about conditional uses, as well as new state law that was adopted in 2017. Okay, so the first case is All Energy versus Trempealeau County. This was a highly contested conditional use decision with 368 people who spoke on record at the public hearing. I imagine it was a long night. All Energy, a mining company, contended that the opponent's arguments were uncorroborated hearsay. The county identified 37 conditions for this silica sand mine, a frac sand mine, then voted to deny the permit based on health, safety, and aesthetic concerns. This was appealed up to the Wisconsin Supreme Court, and the Supreme Court supported the decision to deny this conditional use. All Energy took issue with the fact that the zoning committee denied the permit, even though they found that all the conditions imposed by the zoning committee could be met. The committee referred to the general public health, safety, and aesthetic concerns in denying the permit. A dissenting opinion from the Supreme Court argued for less discretion for local governments. So the question is, what is the correct standard for deciding on conditional uses? And there was people arguing both sides of this, attorneys arguing both sides. One side said conditional use applicants can find support in Wisconsin case law for the proposition that as long as a proposed development is identified as a conditional use for the zoning district in question, a permit should in most cases, and except in extraordinary circumstances, be granted. Under this theory, the fundamental determination that a land use is suitable in a particular zoning district is made when the ordinance is adopted. The focus of a contested conditional use permit application then shifts to whether and to what extent site-specific conditions should be imposed to mitigate potentially problematic impacts of the use. The alternative view, shown in the green box, which would inform the strategy of CUP opponents, is that zoning boards have full discretion to deny the permit application if the standards for approval of the permit are not met. This viewpoint emphasizes the applicant's burden of proof to provide evidence to satisfy each of the ordinance standards. However, it is common for zoning boards to operate under the assumption that the ordinance designation of the proposed development as a conditional use is evidence of its compatibility with surrounding land uses, implicitly shifting the burden of proof to opponents to refute that presumption. So in this case, after the decision of the All Energy case, the Wisconsin legislature jumped in, and they came out somewhere between these two sides. So in 2017, Wisconsin Act 67 created new rules for conditional use permits, and we've got the places in Wisconsin statute where these new rules can be found. They included a definition of conditional use for the first time. It means a use allowed under a conditional use permit, a special exception, or other special zoning permission, but does not include a variance. The process part of deciding conditional uses under Act 67 is that a Class 2 notice is required, as well as a public hearing. A decision by the zoning board. Act 67 always refers to the zoning board deciding conditional uses, and that's at odds with our other Wisconsin law that allows the governing body, the Plan Commission, or the Zoning Board of Adjustment to grant conditional uses. And then within Act 67, it then provides appeals of conditional use decisions would go to circuit court. But ordinances may specify alternate routes for conditional uses. Typically, if the Plan Commission makes the decision on conditional uses, then it would be appealed to the zoning board. And if the governing body makes the decision, it would be appealed to circuit court. Act 67 goes on to outline the local government responsibilities. It states ordinance requirements and conditions must be reasonable, and to the extent practicable, they must be measurable. The local government must support the decision to approve or deny the permit and to attach conditions with substantial evidence. Conditions must relate to the ordinance purpose, and conditions may limit the duration, the transfer, or the renewal of the conditional use. So we see this term substantial evidence, and that was also defined in Act 67. Substantial evidence means facts and information other than merely personal preferences or speculation. It has to be directly pertaining to the requirements and conditions an applicant must meet to obtain a conditional use permit, And substantial evidence is that evidence that reasonable persons could accept in support of a conclusion. So what are the roles, the responsibilities of the applicant? They must demonstrate that the application and all requirements and conditions established by the local governments relating to the conditional use are or shall be satisfied. They must provide substantial evidence supporting the application and demonstrating that the requirements from the ordinance and the conditions will be met. The permit decision. If an applicant for a conditional use permit meets or agrees to meet all the requirements and conditions specified in the ordinance or imposed by the zoning board or other body deciding conditional uses, the local government shall grant the conditional use permit. So in some cases, substantial evidence will be provided on both sides, both to grant and to deny the conditional use. The local government has discretion in how it weighs this competing evidence. A local government still has the ability to approve or deny a permit and to attach conditions. And a local government under our new law either approves a CUP because it complies with the requirements of the ordinance and the conditions imposed, or they deny it because it does not meet some of the requirements or doesn't provide information on how they would meet it. It may be an incomplete application. So the requirements and the conditions imposed, if they don't meet some of those, then it can be denied. Okay, so then we've had a couple of court cases that have come up since Act 67. The first one is EcoSite versus the town of Cedarburg. T-Mobile applied for a CUP to move their cell equipment from the village of Grafton, shown over here on the right, the white land, to a tower to be built by EcoSite, located about 1,300 feet away in the town of Cedarburg on a site zoned A1, this property right here, which listed cell towers as a conditional use. The proposed tower site is surrounded by land zoned as residential. So the yellow, the orange, and the brown is all residential property. This site is in Ozaukee County. So the town of Cedarburg in its zoning ordinance lists 6 standards for CUP approval. The town board voted to deny the CUP because it did not meet the 3 CUP standards highlighted in yellow. The first 2 conditional use standards, health, safety, and welfare, and compatible with adjacent land, were also the 2 that were rated most difficult to apply in a recent survey by Clue. So let's look at how the town of Cedarburg applied them, as well as how the courts responded. The town of Cedarburg, after hearing the evidence, voted to deny the conditional use for a number of reasons. And I would encourage local governments, when you're deciding on conditional uses, to look at all the different standards and write your decision in such a way that it's clear each standard that you feel hasn't been met, or each condition that you apply that you feel they have not or will not meet, they're unable to meet. So what you can see here is the town of Cedarburg said loss in value was one of the issues for surrounding properties. So this is linked to standard 1 that includes welfare, which includes prosperity. Their second reason was it was incompatible with adjacent lands. The town had said in its comp plan that it was trying to keep the area rural and rustic. So that's standard number 2 in their ordinance. Their third reason was it would be detrimental to public health, safety, and welfare. So that's standard 1 in their ordinance. And the last is specific to cell towers. And they said that why was the search ring for other locations to put this cell tower equipment so small? EcoSite appealed the conditional use denial to circuit court, and argued that this 66 section of statute prohibits local governments from denying cell towers solely on aesthetic concerns. Upon reviewing records and briefs, the circuit court ruled that the reasons set forth by the town were not just another way of saying aesthetics, but were in fact legitimate reasons for disapproval, and that there was substantial evidence within the record to support its decision. EcoSite appealed to the Court of Appeals, saying the Telecommunications Act states a local government provide a written decision supported by substantial evidence contained in a written record if a request is denied. Substantial evidence is evidence where reasonable persons could decide as the town did. And the Court of Appeals found that the testimony at the public hearings supported the town's conclusion that the tower would be incompatible with the adjacent residential land. Residents provided sufficient evidence of substantial diminishment in the value of adjacent properties if the tower is built. Their substantial evidence was one resident cited 2 studies showing a loss in property values near towers, and a developer stated he lost a potential sale due to the tower proposal. So the town's conditional use denial was upheld by the Court of Appeals. Just a little diagram showing the process for the appeal of CUP decisions. If the Plan Commission or Zoning Committee makes the CUP decision, it's typically appealed to the Zoning Board. If the Zoning Board or the governing body make the CUP decision, it's typically appealed to Circuit Court, then to Court of Appeals and Wisconsin Supreme Court. Okay, now a second recent court decision that deals with appeals, among other things. This is Highland Sportsman's Club versus the City of Delafield down in Waukesha County. The City of Delafield denied a conditional use permit for a shooting range, stating they had safety concerns, but not specifying the safety concern. This is the Sportsman's Club right here, surrounded by commercial development on one side and residential on a couple of other sides. The Court of Appeals held that the city's denial of the CUP for the shooting range was arbitrary and capricious. When a court says arbitrary and capricious, that means they don't agree with you. They don't think you had good reasoning for your decision. So arbitrary and capricious, and thus invalid, because the city denied the CUP without making any findings. The city had its opportunity to put forth its best evidence and its reasoning, which was found wanting. The city failed to make any findings of fact to support the denial, other than stating the city did not feel the plan was adequate to protect the safety of its citizens. The court said, feelings are no substitute for reason, and reason is what we seek. So the court reversed the city's decision. It said the CUP should be granted, and it did not remand the matter to the city. To remand means to send it back for reconsideration. So the court simply reversed the city's decision. The city took a different tact, and it said rather than issuing the CUP based on this Court of Appeals decision, the reversal, the city held new hearings, took new evidence, issued new findings, and denied the CUP again. This decision was appealed up through the courts, and the Court of Appeals on round 2 quipped, the city does not get a second kick at the cat in these circumstances. The Court of Appeals ordered the city to grant the CUP. So I think that the take-home message here is local governments really have one opportunity to put forth their best evidence and reasoning on a conditional use. After reviewing a conditional use decision, a court has 3 options. They can affirm the decision, they can reverse, like happened here, say the opposite, or they can remand the decision to the local government for further proceedings consistent with the court's decision. In this case, the court's decision was to reverse the decision of the city. Reversal is appropriate when the due process violation cannot be cured on remand, which includes cases like this one, in which the evidence failed to support the government's decision. Okay, and now we have another poll.
All right, our second question. Which type of conditional use has been most controversial in your community? Please select one. Gravel pits or quarries, frac sand operations, large livestock farms, solar or wind farms, shooting ranges, campgrounds, or other. If you select other, please feel free to type in the chat box.
We'll give you a minute to pick the one that was the most controversial in your, or over time has been the most controversial. In the chat box, I see that a gas station is coming up, self-storage, as well as off-premise signs. Another vote for self-storage, car dealerships and repair, recycling facilities, taverns, demolition for parking and green space, home businesses, large apartment buildings and stores that are much taller than nearby buildings, home occupations, industrial uses, meat processing, a bike trail, a drive-through bank replacing a historic property. Okay, so I'll share the results here from this poll. Looks to me like other came in at the top. So we've talked about some of those. A few more came in: parking lots, bars, lounges, telecommunication towers. In second place, we've got gravel pits or quarries. And then it looks fairly similar between large livestock farms, shooting ranges, and campgrounds. So we've got quite a range of uses that can be controversial related to our conditional use application. My suggestion, my general suggestion, and Becky will go into further detail about this, is that especially for these uses that have been controversial in your communities, if you haven't reviewed which districts they're currently allowed in as a conditional use, as well as what the standards are for these conditional uses and whether they're sufficient, please take a look at those in your ordinance. And now Becky will go into more detail about reviewing your ordinance and reviewing your permitting process.
Thank you, Lynn. Is my screen appearing now for everyone?
Now it is.
Awesome. Well, thank you so much, Lynn. Lynn shared a lot of great information. I just want to stop and remind everyone to post questions in the chat if you have them. From the number of controversial issues that were posted, it looks like many of you have found that chat box. We will have time at the end to go over many of your questions as well. I also want to remind you that there is a webinar resource page that Karen linked to in the chat box. It was the very first posting in there. And many of the materials that I have gathered for you are posted there. There's a document right underneath the webinar recording that's called Sample Conditional Use Permit Materials. And I have grabbed examples of communities that have updated ordinances, they've updated their application forms, and they've updated many of their informational materials. So I would encourage you to take a look at that after the webinar. All right, so let's say you have started making some of these changes or you're contemplating them within your community. Where do you go from here? I've laid out two different major processes that you can start looking at. One is to review your ordinance, and the other is to think about your permitting process and how you can update forms and explanatory materials for applicants. You may find in your community that it's much more politically feasible to start with one of these processes, or you may be lucky enough that you can achieve both these processes concurrently. You can start anywhere. All right, so let's start with ordinance review. A few bullet points I have here. Let's take a look at ordinance purpose statements. I also recommend taking a look at how you've classified uses within your ordinance, reviewing specifically the conditional use standards that you have within your ordinance, and reviewing the process that you have laid out in your ordinance. So let's take a look at some of these examples, starting with purpose statements. There's typically at least 3 different areas in your ordinance where you might find different purpose statements. The most common is right at the beginning of your ordinance. There's oftentimes a general purpose statements saying why you have the ordinance in place. You might see these listed as a purpose statement or an intent statement. So this is an example that I've pulled from the town of Newton. Second, I would recommend looking where you describe each zoning district. Oftentimes communities will also list purpose statements associated with each of these districts. So if you're allowing a conditional use permit in a given district, you can refer to the purpose statement for that district to help you craft conditions and to give you justification for crafting those conditions. So if you look at a few of the ones that I've pulled here, you can see there's very different purposes for different districts. Maybe starting at the bottom, the industrial district talks about some common nuisance type issues, such as noise, dust, smoke, odor, traffic, physical appearance, etc. So you could imagine crafting conditions related to these different purposes. In a residential district, you've listed some very different purposes: minimizing impacts to ag resource lands, this is from a town, retaining the town's rural character, and maintaining efficiency and provision of rural government services. So maybe providing adequate services or utilities might be something that you condition your approval on. And then lastly, there's this agricultural district where they're talking about there may be conditions associated with agricultural land uses that are not necessarily compatible with residential use. So you can see they're actually providing protections for farmland in this particular purpose statement. And you may have conditions that would go along with that. And then lastly, the third place that you may find a purpose statement, not every community does this, but if you look in the section that describes conditional uses for your community, you may see purpose statements here as well. Okay, so why am I looking at all these purpose statements? With the new state standards, or the new legislative language that was added, it states any condition imposed must be related to the purpose of the ordinance. So you should find support for the conditions that you are attaching someplace in a purpose statement within your ordinance. The second thing that you can do is to review your use classifications. Many ordinances, many traditional ordinances, will have a long list of permitted uses, conditional uses, and in some cases they may also list prohibited uses. I would encourage you to take a look at those and see, do we want to continue to list all of these conditional uses in our ordinance? If you have a lot, that may be a warning sign that you may want to review some of those and see, can we move these into a permitted category if it makes sense and we can add standards directly into our ordinance? Or in some cases, do we want to remove these altogether? At the time that you're reviewing your uses, I'd also encourage you to think about organizing them in a way that's understandable and more usable. So in this example, the image that I've pulled here is from Marathon County, and they've created a use table. So you can see that they've organized their zoning districts across the top. These are the zoning districts that they have within their community. And then they have uses listed down the left side of their tables. One other piece that I like about this particular visual example is that in addition to stating what's allowed, either as P, permitted, C, conditional, or if it's blank, that means it's prohibited, they've also listed if there are additional standards within their ordinance, and they provide a link directly to those standards. So it makes it very user-friendly and easy to find. All right. Third, I recommend looking at your review standards within your ordinance. You can ignore the section in blue for now. That's kind of the area that you can plug in your own local standards. Each community is going to be a little bit different. What I'm highlighting on this slide and the next is some of that state language and showing you how communities are including that. So in this case, I want you to focus on the yellow text. So here, this community has added that the applicant must demonstrate by substantial evidence that the application and all requirements and conditions established by the city are or shall be satisfied. The decision to approve or deny the permit must be based on substantial evidence. Okay, so you can word this how you choose, but I've been seeing a lot of communities adding this language in directly into their local ordinances. Another piece that was added to state statutes is that standards must be reasonable and measurable. So I really like how this community incorporated that. Right before their local ordinance standards, they created this statement. The Plan Commission and Village Board must evaluate at least the following criteria, which are deemed reasonable and to the extent practicable, measurable. I like how the community has said that yes, we've evaluated these things and we believe that they are reasonable and measurable. It's just giving some added weight to them. Okay. So what standards are included in your ordinance? You have flexibility here. The poll that, or the survey that Lynn mentioned that went out statewide, we asked about what standards are included in local ordinances. And this just gives you a sense of what people are including locally. So some of the most common: no harm to public health or safety, compatible with surrounding uses, site access and traffic safety, consistent with a comprehensive plan, utilities and facilities, stormwater management and drainage, environmental factors, neighborhood character, property values, and aesthetics was the least common. So I've seen a growing number of communities, in addition to those general standards that you might state for conditional uses, they're going into their ordinance and they're adding in specific standards for uses that are either controversial or handled quite frequently as conditional uses. So this is an example that I grabbed showing use standards for accessory dwellings. So anytime a conditional use permit is requested for an accessory dwelling, so an additional home on a single lot, you might think of this like a granny flat, these are the standards that they apply. They also have the ability to add additional ones at the time of granting the permit as well. So for example, it must be located above a detached garage, exterior changes must be of a similar material, no more than 30% of the floor area on the subject parcel, and so on. I think this helps the applicant know what to expect when they're applying for a permit, and it also helps local officials so that they're not in the moment needing to create these standards. It's easier to think about these things in advance and then add additional standards if needed when a particular use is applied for. And then my last tip here is to consider a fourth category. Most communities will list permitted uses, they'll list conditional uses, and they'll list prohibited uses. In many other states, they're actually adding another category that falls right between permitted and conditional uses, and they're calling them restricted uses. This is where the use is permitted, provided it complies with the use restrictions stated in the ordinance. And in practice, there's actually a number of Wisconsin communities that are doing this. They're just simply calling them permitted uses. So in this example, a bed and breakfast is permitted as long as it meets these restrictions that are listed within the ordinance. All right, and then lastly, when you're looking at your ordinance, make sure to review your process requirements. A Class 2 notice and public hearing are required. That is not the notice or meeting that everyone had prior to the legislative changes. If you are a community with no official newspaper, then you may opt to post instead. The example that I have here shows a community that goes above and beyond this publication notice. In addition to that paid published notice in their newspaper, they also mail to the property owner and those within 200 feet, and they post a sign on site. So again, those are optional, but there are ways that you can go above and beyond in your ordinance if you choose to. The other item from a process standpoint that I would recommend reviewing is making sure if you are not having conditional uses reviewed by your zoning board, if it's an alternate body such as the governing body or plan commission, make sure that it's specified in your ordinance to make sure that you do have that authority. All right, moving on to process review. Sometimes it's challenging to crack open that ordinance and to make changes. So an easier place in many cases is through reviewing your process and your associated forms and informational material that you're presenting to communities. Okay, so I've got a number of places to look at. One is your website. Your website is oftentimes the first impression that users have. People go there looking for information. They want an easy explanation of what your ordinance says. They don't necessarily want to look into your code book. They simply want to know about the permit that they're applying for and how to go about doing that. So I recommend reviewing your website to make sure that it has that easy, simple, step-by-step, and friendly language where appropriate. A number of communities are integrating new interactive maps and other lookup tools. It could be something as simple as including those use tables or outlining your procedures, along with links to access all the different forms and information that they need. But think through, how can we make our website and how can we get materials into the hands of our applicants in an easier manner? One example is pulled from Waukesha County. Back in 2011, they developed a guide to permits, licensing, and development services, and they've since moved that completely online. What I like about this is for each type of permit that is being requested, whether it's a rezone, conditional use, subdivision plat, etc., they outline the process for everyone in the same way. So when is this type of permit required? Why is it required? I think this is fantastic if you can express that to the applicant. Who do you need to meet with to get approval? And how does the process get started? There's additional information provided as well, such as a flow chart and application materials. Okay. So I also recommend taking a look at your application packets. This is an example from Waupaca County, where they've laid out what the requirements are. They've provided instructions and a checklist to walk applicants through the process, and they also have examples. So also from that survey that we had sent out statewide, we asked generally, what does your community require as part of a conditional use permit application? We found that probably about 2/3 of communities require a simple application form that's generally lists contact information, and it has the applicant describe their project, but it's not specific to conditional uses. About 1/3 of communities have an additional form or additional questions that they ask related to conditional uses. And then many will require, actually the majority require a site plan. Some require a plan of operation where you're describing a business, how it's going to operate, hours of operation, etc. And then some require architectural drawings and other materials. So I highly recommend you look at your application materials. Make sure that you are prompting the applicant with the application form to address each of your ordinance standards. So this community has 4 simple standards, and they have space for the applicant to respond to that standard, to show that they have an explanation how they meet that standard. Remember, it is the applicant's burden of proof to provide that information. One thing I highly recommend is thinking about fillable forms. This makes things so much easier for both the applicant as well as the local government. It creates a digital record from the start, and it allows the applicant to put their best foot forward. They can revise things and submit it once they know it's complete, rather than handwriting things and submitting things in a willy-nilly fashion. Okay. Lynn referenced creating a decision form. Written decision forms are not required. However, I think that they're very valuable. This is a place where you can establish legally why you are granting or denying a permit. So in a written decision form, I would recommend that you record the facts that you relied upon in your decision making, specifically state how each standard found in your local ordinance was met or was not met, and then state what your decision was to grant or deny it, and whether or not you're attaching conditions, and state those conditions. Another tool that could aid in making that final decision is in developing recommendation forms. So in this example that I pulled from Waupaca County, they require a recommendation from towns that participate under county zoning. So that, again, they prompt them to look at the standards that are applicable to towns. In this case, how is this consistent with your comprehensive plan? You could also take the same concept of a recommendation form and apply it to other review bodies. So for example, if your plan commission looks at something before the governing body makes the final decision, you may want some sort of recommendation form from that review body. And then lastly, think about staff reports. If you're fortunate enough to have staff who are supporting you in your decision-making related to conditional use permits, think about what the format is for that. Think about what type of information you typically need to help support your decision, and you can come up with a standardized form where you can just plug in the same sort of information for each application. All right, so we're gonna end this section with a poll. Lynn, would you like to read this while I launch the poll?
Which of the following actions do you plan to take after attending this webinar? Please select all that apply. Review the uses listed in our ordinance. Review our ordinance purpose statements. Review our standards for granting conditional use permits. Add standards to our ordinance for specific uses. Review and update our application materials. Create a decision form for local officials. Or nothing. Our materials are up to date.
Well, I'm seeing some early results. 3/4 of you would like to review standards for granting conditional use permits. I'll give you a few more moments to keep responding. All right, I'll go ahead and end the poll. So that same response was the #1 response. Review our standards for granting conditional use permits, 74% of you. Next was review our ordinance purpose statements. Review and update our application materials at 51%. And then the next choice was review the uses listed in our ordinance. And there were a number of others as well. So I just wanted to put this here as a prompt to get you thinking about what you could take away from this webinar. What are some future actions that we can get started with? I'll remind you of the sample resources we have listed on that webinar resource page. Oftentimes it's easiest to get started by taking a look at what other communities have done. And so that's what I've tried to accomplish in the second part of this webinar, is to provide examples of things that are of materials that communities are updating and what their approach is, recognizing that you may need to take your own approach. All right, I'm going to close that poll. And I'm going to stop sharing and encourage you to go ahead and type questions that you have in the chat box. And I'm going to start my video. And both Lynn and I are available to answer questions.
I'll just also add, if you'd like to ask a question verbally, you can raise your hand and we can call on you that way as well.
All right, so I'm seeing one question. Many of the conditional use permit standards in the examples provided seem rather subjective. Should communities be reviewing, updating these standards? Have there been any legal challenges to these types of standards since Act 67? So the two pieces from state statutes I would recommend looking at would be the reasonable and, to the extent practical, measurable. So absolutely, I would recommend reviewing your standards and make sure that you think it can meet those two standards. I have not seen any any legal challenges to the standards found in an ordinance, generally courts will defer to local governments and say, what you've enacted legislatively, we're going to give great deference to. That does not mean, now that we have those two new standards, reasonable and measurable, that there couldn't be a challenge to the ordinance itself. Any other questions? We were hoping this would be a very chatty group. We'll remind you that we had some local official webinars prior to this, and they had a lot of questions.
I see the note that reasonable seems hard to define. And I agree with that to some extent. I guess two things come to mind. One is it doable? Not is it expensive, but is it doable? Can it be accomplished? And the second part is, as Becky went over, that all conditions have to be linked back to the purpose of the ordinance. So that would be part of it as well.
All right, so I'm seeing a number of items. The substantial evidence rule intentionally discounts hearsay, opinion, and unsubstantiated assertion. Absolutely. You need, and that's why we encourage you to have those decision forms where you record what the facts are. Oftentimes there's much information presented in favor of an applicant, against an applicant, and you as a decision-making body need to decide what is credible and what information are we going to rely upon. So it's really helpful to state what facts and information you're using when you're making a decision and somehow record that, whether it's on a written decision or it's somehow restated during the hearing so that you have a record of that.
I saw there was a note a little bit earlier asking about communication examples. Here we go. Do you have examples of communication items on how to engage the public? I'm not sure exactly what Josh is asking about, but one thing that comes to mind is for the Zoning Board of Adjustment or Board of Appeals, we have what we call an announcement page, and it's both, hopefully, it's given to the applicant before they apply for any decision made by the zoning board. But also read at the beginning of the meeting where the hearing happens. And it explains basically some of what we went through today, what the role of the of the local government body is, what they base their decisions on, and what the standards are. So I think that can certainly be incorporated in the application, which means that anyone interested in that conditional use permit decision would also get it if they looked at the packet that was available, as well as reading it at the beginning of the meeting so that people who attend understand who's making the decision and what standards that decision are based on.
And Josh added a couple of items to that statement. He's written that they've gotten into tense situation when residents present all manner of unfounded observation or non-factual or non-credible resources, and they are rebutted. So then on the communication question, how to provide or explain the substantial evidence standard.
Mm-hmm.
Another comment from Andy was having all conditions be measurable seems challenging. I think you need to think through, you know, what it says to the extent practicable, measurable. So what is measurable? And I think really the term there needs to be, is this realistic? Okay, is it reasonable? Is it realistic? Is this something that someone could achieve? And do we have support in our ordinance that there's a real need for this as well? It's not just coming up with every single condition that people purposely can't meet. It's, does your ordinance support the fact that you are attaching this condition? Okay, by putting a conditional use in your ordinance, I think you're making the statement that yes, this is something that we can allow within these given districts, provided it is appropriate for the specific location. We may need to attach some conditions to make it appropriate or to mitigate for environmental factors, traffic factors, etc. But generally, we're stating that this is appropriate. A few people have been asking for reposting of those materials. We've posted them a couple of times. You should have also received an email. And the presentation, including the recording today, will be available and posted on that resource page. One person had messaged me privately and was asking about updating their ordinance, and they asked for some examples. I would point you to that sample document. It was called Sample Conditional Use Permit Materials that I've posted on the resource page for some examples to get started with. If you're a very small community or very large community, or feel that you have a very different set of issues that you're trying to address and are looking for more examples, feel free to reach out to me or to Lynn, and we can see if we can point you to additional resources as well. So one more question: worst case scenario, if we delay examining and improving our local zoning ordinance, we are sued, which is expensive, and or end up with a project that is not what the community wants. So one thing I do want to point out, I talked about all these different ideas for updating your ordinance or updating your forms. Okay, sometimes that is difficult to do, especially in small communities that may not have any dedicated staff. These legislative changes are in place and they apply to your community whether or not you've actually updated your local ordinance. So do the best that you can with what you have in place. You still should be applying that substantial evidence standard, meaning you're gathering facts and information both on the local government level as well as the applicant needs to provide those facts. And you still should make sure that your standards and conditions are reasonable and measurable, even if you've not updated your ordinance to state that explicitly.
Becky, I see one question related to comprehensive planning. It says we are under the understanding that CUPs do not need to be consistent with the comp plan.
That is a great question because that is absolutely true. You will see in some local ordinances that people will add the requirement that they be consistent, and you can add that requirement, but state statutes do not require that the granting of a conditional use permit be consistent with a plan. That was something that's been clarified over the years.
Mm-hmm. There's also a comment, we've had high volumes of testimony in opposition that has been speculative. Can a committee attempt to limit the character of the testimony? And I think the answer is yes, you certainly can. Providing the definition of substantial evidence, letting people know that it needs to be facts and information. They need some backup, either whether that's photos or whether that's some report that was written, possibly even including that on your public notice so that if people don't come to the zoning office or request further information, that they know when they come to the hearing that that's the situation, as well as announcing it at the beginning. It's hard to, get the testimony narrowed down to what you would like it to be, but you can certainly take those steps in trying to do that. Another thing that some boards and committees that decide conditional uses say, because it's based on evidence, not opinion, not how many people are for and how many people are against, you can ask people to not provide repetitive testimony. So if a fact has already been presented as evidence, it doesn't matter if one person presents it or if 10 people present it. It's still the same fact. It still comes with the same weight.
There was a fun comment from Cindy. We really like your backgrounds, meaning what you see behind us for our virtual backgrounds. With new virtual zoning board meetings, they're thinking about implementing pleasant backgrounds in hopes of having a pleasant public hearing. I like that comment, but that also brings up one more point. We are exploring future webinar topics, and some ideas that we've been kicking around is related to public participation, and I know many of you are operating in virtual environments. So if there's topics related to, how do we conduct hearings in those types of settings, or other topics that you think of, feel free to put those in the chat or reach out to either Lynn or I by email with some additional ideas for future presentations. And then one more comment from Joy. The findings of facts is so important to include facts only and not opinion. If the board has an opportunity to research case law concerning a particular request prior to the hearing, both for or against the conditional use, it helps to put the decision in perspective. I would agree with this. I think findings of facts, and sometimes there's competing facts, and so at least stating what facts you're relying upon to make your decision is going to help support your decisions from a legal standpoint if they were ever appealed. All right, well, we are just over 11 o'clock. We welcome additional questions after the webinar. If you have a chance to reach out by email or need to give one of us a call, we are more than happy to assist with some of those questions or future training requests. Thank you so much.
Thank you.